Hi, my name is Oliver Bondracharya, and I'm a partner here at Roca Rothgerber Christie.
My name's Drew Wilson. I'm an attorney here at Roca Rothgerber Christie.
And we're going to be talking about rights of publicity and trademark rights, and what are the differences between those two types of rights here today.
And really, how you can use both to best protect your persona.
These days, being an influencer, there are a lot of mediums that you can be exposed to a large number of people on the internet. And so if you have a broadcast, a YouTube channel, if you're selling goods on the internet, if you're making content, there are lots of ways to be featured. And there's also lots of ways that other people might be able to take your image or your likeness and use it. And here are some ways that you might be able to prevent them from doing that.
Rights of publicity are rights in your persona. So things like your name, your photograph. But it can also go a little further. It can also be the sound of your voice. Rights of publicity can also go beyond even that. In fact, there was one case where a company made a robot of a woman who was changing letters at a game show. And Vanna White sued and was able to win on a right of publicity claim, saying that that evoked her rights of publicity.
A trademark is essentially a brand name. It's a name that people associate with a certain good or service. For example, everyone understands that Coca-Cola is a brand name for the sale of a soft drink. Well, trademarks can be used for people too, and people can have rights in their names. For example, Kylie Jenner has registered the name Kylie for use in association with cosmetics. And so Kylie can prevent the use of the name Kylie with respect to other people selling cosmetics because she's got the rights for herself. However, trademark rights are associated with a specific good or service. So, for example, if somebody were selling car tires under the name Kylie, if Kylie doesn't have that name registered for car tires, then she may or may not be able to, but less likely be able to, enforce her rights with respect to car tires using the same name, Kylie.
Rights of publicity in some ways are much, much more powerful than trademark rights. With trademarks, you can prevent others from using a particular mark or logo that is confusingly similar to your mark or logo, so long as the use is in close proximity to the goods and services that you are using that mark and logo with. However, under her rights of publicity, you can prevent someone from using your right of publicity, your persona, in connection with goods or services that you've never exploited your persona with, that you've never used your persona in connection with. So in that way, it is a much more powerful tool than trademark rights.
Another difference between trademark rights and rights of publicity are that trademark rights are, if you get a trademark registration, you will have rights throughout the United States that are the same, no matter what state you're in. However, with rights of publicity vary from state to state, and some states don't even have a right of publicity. If you're going to enforce your rights of publicity, you would have to determine what the particular laws are in each state before you can advocate for your rights, and they might be different from state to state. For example, some states, even though they may have a right of publicity statute, the right does not extend past death. Or if you do die, there might be a different length of time that the right of publicity extends between, for example, 20 years and 100 years. And so you have to make sure that you know what the law is in each state, as opposed to trademark rights, which are the same throughout the country.
And another benefit of trademark rights is that so long as you or a company that you're working with uses the trademark right can last indefinitely. Rights of publicity, for the most part, with very limited exceptions, do have a termination date. Another question that people might have is, well, why can't I just always rely on rights of publicity? They seem so much more powerful than trademarks. Well, the problem is only about 35 states actually recognize rights of publicity. So if the harm that occurs that you're trying to prevent is in a state that doesn't recognize rights of publicity, you might have a really hard time enforcing those rights of publicity.
You might be wondering, we're talking a lot about celebrities like Kylie Jenner and Vanna White, which are all famous people that everyone's heard of. And so, do you have to be famous to have a right of publicity? And the answer is, you don't have to be famous. Everyone has a right of publicity. It's your image, it's your name, it's your likeness, and therefore you have that right. The difference is, what is the value of your right of publicity? For famous people, they are able to use their image and likeness to sell all sorts of goods and services, or they may be able to, and people might be willing to buy those goods and services because they recognize the celebrity that's selling them. But if I try to sell goods and services with my image may not be as valuable because people may not recognize me as being famous, and therefore I may not have that much of an influence with respect to those goods and services. So even though I have a right of publicity that I can enforce, I might not be able to get as much money for my rights of publicity as a famous person would or a celebrity would with respect to their rights of publicity.
But what's nice is you'd still be able to stop the use. So if your likeness is being used on a product you disagree with, or that you just feel that it's unfair, you can still get an injunction, even though the monetary damages might not be as high as if you were a celebrity. Trademarks are sort of unique in that trademark rights come from use. So really, you don't have to file for a registration in order to have trademark rights that you can enforce against third parties. You just have to have been using your name or whatever it is that you're trying to protect in association with a particular good or service for a significant amount of time. Now, there are certain benefits with obtaining a federal registration. You can file that registration with Customs and Border Protection, who will stop people from importing goods that have an infringing version of the trademark. There's also the benefit that your trademark is presumed to be valid and is also presumed to have what's called secondary meaning. If you don't have a trademark registration and you seek to enforce that trademark later on, you might run into a problem that you're required to show that people associate that mark with a single source. Whereas if you had the registration ahead of time, that's not necessarily going to be an issue.
As we mentioned before, everyone has a right of publicity. Everyone has their own likeness, their own name, their own signature, their own voice. Your right of publicity is associated with you. Some states have rights of publicity laws. So if you are in a state that has a right of publicity law, and if somebody is misappropriating your likeness or your image, you can take advantage of that law, and if you meet the requirements or the elements of that law, you can prevent other people from using your right of publicity, and in some cases you might be able to obtain money damages from their use of your likeness if they made a profit from selling goods or services that use your likeness.
It's also worth noting that in some states, particularly California, where there's a posthumous right of publicity, you actually have to register that right with the state in order to enforce it going forward. So you don't, in California, have to register your right of publicity while you're alive, but if your estate or your heir and assigns wants to enforce it, they do have to register it.